The most important thing to understand about these bills is that they are customs and tariff measures. They are not a ratification of the Comprehensive and Progressive Agreement for the Trans-Pacific Partnership, known as the TPP-11, which the government signed in March this year. Australia's Parliament is not given the opportunity to ratify the trade treaties of this sort, and this is why Labor is proposing that substantial reform of the treaty-making process is necessary. Our view of what must change is set out in a second reading amendment, which I shall move later, and in a private senator's bill, which I shall introduce. TPP-11 replaces the former Trans-Pacific Partnership, or TPP-12, which included the United States. The other signatories to TPP-11 are Canada, Peru, Chile, Mexico, Japan, Vietnam, Malaysia, Singapore, Brunei and New Zealand. Labor has always been absolutely clear that we have serious concerns about aspects of TPP-11, as we did about TPP-12. Supporting these customs and tariff bills does not amount to the full endorsement of the agreement in its present form. The agreement included investment state dispute settlement, ISDS provisions, which Labor opposes. ISDS provisions allow foreign companies to sue national governments. These provisions compromise Australia's sovereignty by limiting the ability of Australian governments to act in the national interest. In government, Labor will not agree to include such provisions in trade agreements and will seek to remove them from existing agreements. We note the Ahern government had successfully negotiated the removal of TPP-11's ISDS provisions as far as New Zealand is concerned. So there is a precedent for the removal of these provisions. It's not a matter of being locked into them forever. The agreement also waives labour market testing for contractual services suppliers for 6 countries in Canada, Peru, Mexico, Brunei, Malaysia and Vietnam. Labor believes that trade agreements must not be used to undermine Australia's immigration system. And the waiving of labour market testing contradicts a commitment by the former Prime Minister, Malcolm Turnbull, that testing will take place before applications for temporary skilled shortage visas are granted. As Labor members of the JSCOC inquiry into the bill noted, more than 450 professions could currently be covered by the term contractual service supplier. They include electricians, plumbers, carpenters and nurses. No other country has provided Australia with such generous reciprocal visa rights, and it is unclear why such concessions were offered by the government. Labor acknowledges that foreign workers play a role in the success of our economy, but it is a fundamental principle of fairness that Australians should be offered work first and that foreign workers brought into Australia only for a demonstrated need. The temporary migration system is intended to supplement the skills of Australians. It is not meant to remove the ability of Australians to get jobs. And in government, Labor will seek to reinstate labour market testing for contractual service suppliers and will not allow such concessions in future agreements. Labor is also concerned that the ISDS provisions in the agreement will leave Australia vulnerable to protracted legal disputes with foreign-owned corporations. Senators will recall that the global tobacco corporation Philip Morris used the ISDS provisions in early agreements to overturn the Australia plain packaging legislation for cigarettes. They sued the Australian government in the Singaporean Register of the Permanent Court of Arbitration. Now, Philip Morris was not successful, but it's idle to say, as some do, that the outcome of that court action shows that there is nothing to fear from the ISDS clauses in trade agreements. It is outrageous that the case ever got to court in the first place. And there was no guarantee that future cases initiated under ISDS provisions would end successfully for Australia. And that's why the former Labor government excluded ISDS provisions in early negotiations on the TPP. Remember that the Howard government also had such concerns and excluded ISDS provisions in Australia's free trade agreement with the United States. Well, the present Liberal government evidently does not have those concerns for Australia's national interest as John Howard did. Warnings about the dangers of ISDS provisions in trade agreements have been issued by the Productivity Commission, an agency that could hardly be called a den of die-hard protectionists. In 2010, the Productivity Commission reported on bilateral and regional trade agreements and commented that, commented that Australian government should, and I quote, seek to avoid accepting provisions in trade agreements that confer additional substantive or procedural rights on foreign investors over and above those already provided by the Australian legal system. The Commission report also stated, and I quote again, there does not seem to be an underlying economic problem that necessitates the inclusion of ISDS provisions with agreements. And I go on. Available evidence does not suggest that the ISDS provisions have a significant impact on investment flows. Experience in other countries demonstrates there are considerable policy and financial risks arising from ISDS provisions. And in its Trade and Assistance Review of 2013-14, the Productivity Commission included the following observation, and I quote again. The inclusion of ISDS provisions in Australia's preferential trade agreements and bilateral investment treaties have become contentious. The provision departs from the national treatment principles by affording substantive appeal rights to foreigners not available to domestic firms and risks impeding domestic regulatory reform, including safeguards and carve-outs of certain effects, and lacks the transparencies and have the adequate parliamentary scrutiny. This substantial scepticism about ISDS provisions by an agency that I think many in this chamber regard as an advocate for the free market should have been a wake-up call for this government. So in government, Labor will eliminate the dangers posed by the agreements with ISDS provisions and labour market waivers. We will follow the example of the New Zealand government and negotiate side letters to the agreement to release Australia from those aspects of any agreement. A shortened Labor government will not stop there. As the member for Blaxland announced in his speech on these bills in the other place, he said Labor will introduce legislation prohibiting the inclusion of ISDS provisions and waivers for labour market testing in future trade agreements. The Labor will establish a system of accredited trade advisors from industry unions and civil society groups to consult on draft texts of agreements during negotiations. The Labor will legislate to require that an independent national interest assessment be conducted on every new trade agreement before it is signed. That Labor will strengthen the role of Parliament in trade negotiation by increasing the participation of the Joint Standing Committee on Treaties. Joe Scott. Joe Scott will also provide with a statement of objectives for the negotiations for consideration and feedback. And Joe Scott will be briefed on, at the end of each round of negotiations. So Labor has already announced that in government we will introduce a science and medicine and academic and research or smart visa to remove the obstacles created by this government's clumsy draft temporary work visas. Although Labor supports the labour market testing to ensure that Australians are not disadvantaged when employers seek to hire from overseas, we also understand that for Australia to maintain a world leader in innovation, science and medical research and in high-tech industries, we need to access the very best minds from around the world. And so the Smart Visa will provide a path for permanent residency for educators, for innovators and researchers of global standing. And a shortened Labor government will establish Australian Skills Authority, will seek advice from this authority about industries to determine the skills and the areas of specialty available for smart visas. Also, that the minimum level income for the visa will be set in consultation with industry. So Labor's changes will remove the secrecy that surround the negotiation of trade agreements. And for example, the government's refusal to commission independent economic modelling of the TPP-11, the agreement which is of course the subject of this bill, which I find incredible. Senator Birmingham has reported in The Australian this morning that saying that the failure to adhere to the TPP-11 would cost Australia some $15.6 billion in export income. Now, he didn't acknowledge the source of this figure. He didn't say, in fact, where he was relying on these projections. It was, in fact, the report commissioned by the Minerals Council and other groups, including the Business Council, the Australian Industry Group and the Food and Grocery Council. The government itself did not commission independent modelling that would be, you expect, publicly available during the negotiation process. And that's, I think, one of the problems with the present treaty-making process, which Labor will seek to rectify. The Victorian Labor government did commission independent modelling by the financial consulting firm Grant Thornton. That report concluded that participation in the TPP-11 would result in a modest initial gain for Australia, primarily from agricultural goods. The analysis concluded that although the TPP-11s would not benefit all sectors of the economy equally, no sector would be worse off. Now, that judgment would be qualified by other data in the Mineral Council report, data that the Minister Birmingham did not cite in his media interview this morning. The report prepared by Peter Petrie and Petrus University and Michael Plummer from Johns Hopkins University in the United States states that adherence to the agreement would slightly reduce Australia's output of durable manufactured goods. That is because other countries participating in the agreement have comparative advantages. Petrie and Plummer, like Grant Thornton in their analysis for the Victorian government, described the benefits for Australia under TPP-11 as relatively modest. They estimated it to be below 1% of real income. And by 2030, Australia's adherence to the agreement would result in a 2% fall in durable manufacturing. Petrie and Plummer say, and I quote, "Trade agreements that deepen economic relationship with Asia lead to higher net imports of manufactured products." We should also note that independent economic analysis of the original Trans-Pacific Partnership Agreement, the TPP-12, the forerunner of the agreement that is the subject of these bills. This agreement is sufficiently close to the TPP-12 for it to retain the provisions that would be activated should the US choose to join. So the independent modelling that was done for the early agreement continues to be relevant for the present one. And under modelling for the World Bank, the projected economic benefits for Australia under TPP-12 were very modest indeed. The World Bank projected a 0.7% increase in GDP to 2030. That amounts to a 0.07% increase in GDP per annum. An increase on that scale is nothing more than a minor blip. With the new agreement, the TPP-11, nothing seems to much have changed. And I have noted that the evidence of the independent analysis prepared by Grant Thornton by the Victorian government also projects very modest economic benefit for Australia. So what is it that the Australian government has given up in exchange for this modest benefit? It's given away labour market testing that protects Australian workers' rights. It's agreed to the provision under a future Australian government that would be sued by foreign companies. It has made decisions with presumes that are in the strategic interest of the country. And therefore we'd argue that on balance, Labor supports this agreement. The absence of the US in this agreement means that some of the odious aspects of the TPP-12 have been suspended. This agreement suspends contentious provisions in the original agreement related to the biomedical products, copyright and some aspects of ISDS. Australian farmers, manufacturers, exporters of services will gain increased market share and tariff reductions in economies with nearly 500 million consumers. And in 2016-17, nearly a quarter of Australia's exports, worth $88 billion, went to countries participating in this agreement. The agreement will remove 98% of tariffs in trade zones spanning the Asia-Pacific region, with a combined GDP of $13.7 trillion. The agreement creates Australia's first-time agreements with Canada and Mexico. And for the first time, Australian exports will gain preferential access to two of the world's top 20 economies. And for these reasons, and acknowledging the modest economic benefits estimated by the Modelling Commission by the Victorian government, Labor supports the bills. It would have been better if there was been Australian government modelling to actually demonstrate independently the benefits of these arrangements. We stress, however, that these are trade agreements which can't be changed through this process. It will require a change of government to change that process. There must be an end to the secrecy. And before an agreement is signed, it must be demonstrated that there be a net benefit for the Australian participation in the agreement. Provisions in the existing trade agreements that undermine Australian sovereignty and conflict with the principles of Australian migration system must be removed. To rely on assurances of economic benefit that have not been demonstrated while surrendering the basic rights of Australians is an affront to democracy. The democratic principles that should guide any future trade agreements between Australia and other nations are set out in the amendment in my name. And I urge all the senators to actually support that vision. And accordingly I move, at the end of the motion, that the Senate acknowledges that this is a preferential trade agreement, cannot be amended by these bills, only accepted or rejected, and in the opinion the way in which Australia negotiates trade agreements of the type needs to change. The role of the Parliament in trade negotiations should be strengthened by increasing the oversight of trade negotiations by the Joint Standing Committees on Treaties, including providing the committee with a government statement of objectives for negotiation, considerations and feedback, regular briefings at the conclusion of each round of negotiations, and calls on the Australian government to seek to remove investor-state dispute resolution mechanisms and reinstate labour market testing for contractual service suppliers and existing trade agreements, ensure that future governments are prevented by legislation from including ISDS mechanisms or waiving labour market testing in future trade agreements, and establish an accredited trade advisors program to allow industry unions and civil society groups to provide real-time feedback on draft trade agreements during negotiations, subject all new trade agreements to independent national interest test assessments, examining economic, strategic and social impacts before they are signed, enforcing mandatory skills testing in the comprehensive and progressive agreement for Trans-Pacific Partnership and all future trade agreements, and fix the problems in existing skills testing regime by ensuring the skills...
Thank you, Senator Carr. Your time is